Our immediate reaction is that a lot of the issues that were raised as grounds for our petition were not addressed. Maybe because the court had to summarize its ruling or judgment, and so some of those areas were not captured. But the major ground of our petition, particularly the fact that the resignation of the third respondent, the governor of Rivers State, was not authenticated, we were not comfortable with the resolution. The onus, on the basis of the pleadings before the tribunal, the onus is on the petition, on the respondents, who said that the governor resigned. We said he didn't resign. They said he resigned and gave particulars that he resigned. Mentioned the date he resigned, and the date was accepted. Those pieces of evidence were not brought before the court. On the state of the pleadings, it is the man who asserts that somebody has resigned, but who didn't bring the evidence, that stands to lose, according to the Evidence Act. So that's our position on that. We also raised the fact that a lot of the exhibits the respondents brought before the court were not competent because it were not filed alongside their replies to our petition on the basis of paragraphs 12.3 and 41.8 of the first schedule to the Electoral Act. And the court had ruled on this point before, on the 19th of June 2023, that we were a bit faster than our legs. We should have waited for the hearing. And in its ruling, it said at the hearing, if they did not comply with what the section says, of course, that those evidence will not be accepted. We are very surprised that the court again revisited that matter, pretended as if there was no ruling on it before, avoided all the arguments we raised, that they didn't comply, at least seeking the leave of the court to bring in all the papers they did. And they didn't consider it again. So the court has no powers to sit on appeal on a ruling it has already given in the guise of taking the entire judgment and rulings at the time of judgment, delivering of judgment. So that's another point we are going to interrogate on appeal. And on the whole, we raised the issue of the radical issues the Electoral Act have raised, have provided for in the Act of 2022. The fact that documents that are before the court has powers to interrogate them, to look at them. Well, when we get the full judgment, we'll see how they meander through the arguments. But certainly, I can speak from our client that we are not satisfied with the judgment. I will certainly seek further. We'll travel further. My name is Pastor Chigozrem C. Nwodo, NWA-ODU, and I am standing with Mrs. Chioma D. Atandi Kiari. Yes, for the Labour Party. Thank you.